Hi folks, and welcome back to Contract Law. This is video 5 in our video series on contents of a contract and exclusions. And in this video we are going to look at incorporated terms. Now, incorporated terms are a little bit like collateral contracts in that they are terms that are outside the main body of contract terms. Nevertheless, the court is searching around and trying to find a way to enforce them. So as we saw in the last video, in this video series, with collateral contracts, the way that the court went about enforcing those was as a separate and complete in itself contract that floated kind of alongside and operated auxiliary to the main terms of the body in the main contract. The terms that are incorporated by various different means here in this video similarly are terms that have been left out of the main body of the contract, but they're kind of swept in to the contract, not in a physical sense, they're not included in the main body of the contract, but they're kind of somehow brought in. They are incorporated. Okay, so the main forum, or setting, I guess you could say, for discussion of terms that are incorporated often tends to be around nasty little things called exclusion clauses. And we'll talk a bit more about exclusion clauses at the very end of this video series. But just kind of bookmark that little fact because it might help you to appreciate some of the cases that we're going to discuss in this video. There are a couple of things that you need to know before we launch into our discussions of the various different ways that you can incorporate terms into a contract. Now, first relates to notice. There are a couple of different kinds of notice that you need to be aware of. The first is actual notice, and that is where the person is actually aware of the term, the representation, the statement, or whatever that is purportedly incorporated into the contract. So someone has said, here are these terms that I want to be incorporated into this contract. Why don't you read them? Once you've read them and you knew about them, that would be actual notice of the terms. The second is a little bit more fuzzy, I guess, and we call it constructive notice. And constructive notice pops up in a number of different areas of law. In terms of contract law, constructive notice is where a party might not actually have actual notice, of the terms, but nevertheless, so far as the law is concerned, in the circumstances that have been shown to the court, they should have become aware of the terms. And because they should have become aware of the terms, it is said basically that they are constructively aware of those terms. That normally happens where, for example, someone has taken reasonable steps to bring the terms to that person's notice. And so notice might be actual notice or something less than actual notice where someone's done the best they could to tell you about the terms that they want to bring into the contract. Now, why is that even relevant? Why am I kicking off the discussion with this little snippet of information? It's because terms can only be incorporated as contractual terms regardless of where they are. They can only be incorporated into the bargain if the parties have assented to the terms. Now, you can't assent to terms that you don't know about. So you're going to have to know about them either actually or constructively. Okay, so moving on from there. So what I want to do now is have a look at the various different ways that terms are incorporated into the contract. But first we need to kind of back up and make sure that we're all crystal clear on something. So you'll notice in the previous slide, I said that generally speaking, when we're talking about incorporated terms, we'll be talking about terms that have been somehow left out of the main body of contractual terms, but you still want to enforce them anyway. Yes, that is actually most of the times that you'll be using the phrase incorporated terms. But if you kind of think about it from the ground up and you bring in that notion of assent, you might ask yourself the logical question, well, how is it that the terms of a contract, a written contract, are assented to? What is the thing that makes those written terms in the main body of the contract justiciable? And normally when you're talking about a complete discussion of incorporated terms, you will start at the very beginning.
Let's start at the very beginning.
And the terms of the contract in the main body are incorporated and made justiciable by signature. That's the traditional way that you will start off your discussion of incorporated terms. So if you've signed the document, because signature is such a serious undertaking, you'll probably be bound for it, even if you haven't really read the terms properly. So the main authority here is Lestrange and Gorka. That involved the sale and purchase of a cigarette vending machine in the bad old days. This was 1934. And what happened there, the contract included a merger clause, which we've already discussed previously in terms of our second video on the parole evidence law. And that clause read, this agreement contains all the terms and conditions under which I agree to purchase the machine specified above, and any express or implied condition, statement or warranty, statutory or otherwise, not stated herein is hereby excluded. So the typical kind of merger clause. So what happened? Things went pear-shaped. Actually, the machine was defective. Mrs. Lestrange tried to sue Gorka Limited for the defect in the machine. She argued that there was a breach of a statutorily implied term of fitness for purpose. When you sell something, it's got to be fit to do the thing that you say it will do. We will be looking at implied terms in the next video in this series, and we will be looking at statutorily implied terms of fitness for purpose elsewhere in this unit, in other video series. But unfortunately for Mrs. Lestrange, because she had signed the contract for the vending machine, which included that nasty little exclusion clause, it was held that she had to stand by what she had signed. She was bound by the exclusion clause, and she couldn't claim breach of the statutorily implied term. Now, you'd have a lot of trouble arguing that kind of case today, because you actually nowadays can't exclude the statutory implication of fitness for purpose, but we'll talk about that in another video. So that's the main case of Lestrange and Gorka. If you've signed a contract, 9 times out of 10, you're going to be bound by the terms of that contract. They have been incorporated by your signature, even if they do nasty things like that. However, the rule of incorporation by signature is displaced in a number of ways. And the first and most logical way to displace the rule is by arguing successfully that, in fact, the signed document has no contractual effect. Now, the conceptually more easy case to kick off discussions here is the Hill and Wright case. And this was a little case that involved carriage of machinery, and it was a verbal contract between the parties, and what happened was the machinery was carried, it was delivered, and then after delivery a couple of documents were handed to the recipient, who signed off on the documents, and the document in question contained one of those nasty little exclusion clauses excluding liability for damage. Now, this carriage of machinery went on for several months, about 7 months I think it was, and there was somewhere like 10 separate times that these documents had been handed to the recipient. After the machinery had been delivered, they signed off, and it kind of looked as though they were acknowledging that there had been this exclusion for liability for damage. Ultimately, on another occasion, the machinery was carried, it was damaged in transit, and the question was whether the transport company could rely on the exclusion clause that was contained in the paperwork. And in that case, the documents had always been served after the machinery had been delivered. So notwithstanding that they had been signed off, you couldn't really say that they had contractual effect. There was nothing in the document that was agreed to before performance of the contract. The contract was the verbal contract at the very beginning. Each of the times that the documents were delivered after that, essentially just, they looked like delivery dockets almost. You couldn't really say that they had some kind of contractual purport. The harder case, so that's the case where you've got the documents being served after performance of the contract, and clearly there's going to be no contractual effect. Okay, the slightly conceptually more difficult case is where the document is signed at the same time as performance of the obligations, and that's what happened in the Warmings, Used Cars and Tucker case. And this was the sale and purchase of a vehicle between two used car dealers. And what happened was there was a verbal agreement to sell and buy the vehicle on the one day. The next day, when the purchaser finalised the transaction, they asked the seller to sign their purchase book, and that signature in the purchase book was required by statute. Now, it represented that in the purchase book, it represented that the vehicle was the property of the seller and they had good title to pass on. And you guessed it, the seller didn't have good title to pass on. The question was whether there had been a term incorporated into the contract that the selling dealer had good title to pass on to the purchaser. And it was the court's opinion that there was no such term incorporated into the contract. It was the court's view that the earlier verbal agreement constituted the bargain between the parties, and unless you could show some kind of evidence of a new contract that somehow varied the original verbal agreement and was signed off on, then the terms of the verbal agreement would prevail. And no evidence was forthcoming, and so the verbal agreement prevailed. No warranty that the seller had good title. So that is the issue of incorporating terms into a contract by signature. So Lestrange and Gawker, the very basic situation of you can't deny the terms that are contained within the contract itself that you've signed, fairly obvious. But then it kind of teases out into some more difficult, nice questions when you try and get around that rule and you're trying to introduce terms into the contract by way of a document that is separate to the main body of the contract that you've signed off on. So what are some other ways that this notion that terms might be incorporated by signature can be defeated or displaced, apart from arguing that the thing has no contractual significance? Well, you can say that the document you signed was, the contents were misrepresented to you, and misrepresentation will be covered in more detail elsewhere when we do vitiating factors, but essentially that's what happened in the Curtis case. Poor old Mrs. Curtis dropped off her wedding dress to the dry cleaners, was handed a receipt with some printing on it. She said, "Oh, what's all this?" The lady said, "Oh, we just asked you to sign because we need to cover ourselves in case there's damage to beads or sequins." Mrs. Curtis thought, okay, fair enough, signed the document. In fact, the document contained a much wider exclusion clause that covered the dry cleaners for any damage whatsoever. And eventually the wedding dress came back. It was horribly stained, and Mrs. Curtis sued. The dry cleaners tried to rely on the exclusion clause that was printed on the document that Mrs. Curtis signed, and she was able to avoid that term because the contents of the document had been misdescribed to her. So there's another way to get around that notion. Another way is by a little action that we call non-est factum. Non-est factum, it's just Latin for "it is not my deed." And the case that established, sets out probably most clearly this rule is Galley and Lee. And what happened there was Mrs. Galley had this house that was on a long hold lease interest. She liked her nephew very much. I think his name was Parkin. She wanted to gift this leasehold to Parkin, and Parkin came round. A deed was signed. Mrs. Galley didn't have her glasses with her, so she didn't read the document. What happened? The deed actually was prepared by Lee and Parkin, and it ended up that it assigned the leasehold interest to Lee instead of to her nephew. What did Lee do with the title to this leasehold interest? He went off and mortgaged it, raised some cash, and spent up big time. When he defaulted with the bank, well, the bank called in the mortgage and tried to enforce it against Mrs. Galley. Mrs. Galley tried to argue non est factum, and there are a few requirements for establishing non est factum. That is, the document you've signed was not actually your deed for some reason, and you have to be a claimant that belongs to a particular and very narrow class of people. You have to be either unable to read or unable to understand the whole purport of the contract, so you're not even aware of the motions that your hand was performing when you signed the document. Okay, so she didn't read the document here, and she had Parkin and Lee describe it to her. Even if she fell into the relevant class, the problem is then the next requirement is that the claimant has to believe the document was radically different from what it actually was. And here is where she really fell down, because Mrs. Galley knew that she was essentially giving away her leasehold interest in this property. The court said, well, whether you gave it to Parkin or whether you gave it to Lee, the thing is what you signed was a deed that was assigning your interest away. It's the same thing. It's not radically different as so far as the law is concerned. Whether it goes to one party or another is, almost a trifling matter so far as the law is concerned. The essence of the document was an assignment. And the last requirement for non est factum is that, at least against innocent parties, the claimant's failure to read and understand the document is not due to carelessness on their part. Note that this business about the failure to read and understand the document wasn't due to carelessness. That's actually a subjective test. Wow, folks, this doesn't happen very often in contract law. So file that one away in your memory banks. What I might do, folks, is, because this video is getting a little lengthy, is we'll chop it in half, and we will come back for part 2 of incorporated terms, and then after that video we will move on to implied terms. So come back for video 6, and then it looks like video 7. Thanks, guys. I'll see you soon.